Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Today we'll be taking up Colley versus State and Colley versus Secretary, Department of Corrections, numbers 2024-1011 and 2024-1647.
Good morning, Court. My name is Ali Shakur, along with co-counsel Deborah Bell. I have the pleasure of representing James Colley, Jr. This is an initial post-conviction case. Although we stand on all of the issues that we raised and pled and appealed and petitioned, today I plan on spending my time discussing cumulative penalty phase relief with a specific focus on issues 6 and 7. Mr. Colley sits on death row because of the prejudicial, undue influence through the testimony of a sitting courthouse judge, a county judge, Judge Tinlin, who testified on behalf of the state in the capital case. His testimony was inadmissible, and if his testimony was admissible and we submitted was not, trial counsel should have moved to have the case moved to a different circuit.
Was the judge subpoenaed to be there, or did the prosecutor just give him a call and say, come over and testify?
The prosecutor called this judge to testify for the state.
No subpoena?
I can't recall if there was a subpoena or not, but he was compelled to testify for the state.
The judge presided over, the same day of the murders in this case, the judge presided over a domestic violence injunction or something like that?
An injunction proceeding, yes, sir.
And your client pled guilty to that. It was a negotiated plea?
Correct, sir.
To a misdemeanor?
Correct.
And the judge conducted a plea colloquy?
The same morning, correct.
And now, that entire hearing that the judge presided over was videotaped.
Correct, it was.
And that videotape was also introduced into evidence.
Yes, it was introduced.
It was played for the jury?
Yes, it was.
So the entire colloquy that the judge testified about, the jury got to see.
The jury got to see the colloquy, but the colloquy was not very good quality. The video was not very good quality. And Judge Moss mentioned that at the case management conference. The video was not of very good quality. So the state aimed to put this judge on the stand, Judge Charles Tidlin, a county judge, to testify for the state in rebuttal to Mr. Colley's testimony and Mr. Colley's presentation regarding the fact that he was impaired at the time of the crimes. So the state put on a sitting courthouse judge, Judge Charles Tidlin, with 28 years of experience on the bench in that same courthouse.
Right, but your argument isn't that a judge can never be called as a witness, is it?
No, we're not saying
that. And your argument isn't that whether or not the judge can be called as a witness depends on how many years of service he has, right?
Not specifically, no.
Okay, so then focusing in on the point you're actually trying to make, and I'm following here Justice Labarga's question, it would seem to me like if the defendant has put in issue his competency or his state of mind or state of impairment that morning, the judge would seem to be a witness to his state of mind. What am I missing? Did he testify in a robe? Did he, tell me what indicia of credibility that are undue that the judge's testimony had that is supported by the rule you're asking us to adopt?
When he testified, he was referred to as judge.
Okay, so
judge.
So let's stipulate let's stipulate that it would have been better if somehow that had been, I don't know, avoided. Is that the error? If a judge testifies, don't call him judge or don't call her judge?
The error is calling the judge to testify, particularly in a capital case, when there's not a compelling need for that judge's testimony.
But your client put into evidence the state of his impairment.
Right.
Right?
So,
they put that at issue.
Correct. And the state should have called another witness.
Well, okay, I understand that the state could have called someone else sitting in the courtroom, but that's not really the question before us. The question is whether the state cannot call this witness, who, like any other fact witness, was present, right? Had an observation of the defendant's demeanor and interaction with him. It would seem to me like he possesses relevant evidence. So then the question as an evidentiary matters becomes whether there are things that overwhelm the relevance of the testimony by making it prejudicial in some way. And I'm not hearing what specifically causes that in your argument. You've said it isn't You're saying maybe it was the fact that he was referred to as judge. Is that what you're asking us to hold?
Well, it's not just that, the fact he was referred to as a judge, and there has to be a compelling need for a judge's testimony. Even the cases submitted by the state, and the state did do an answer brief in this case, and the state cited to a case called Rodriguez versus State. And in that case, Rodriguez wanted the trial judge, in Rodriguez, the trial judge actually testified in post-conviction. But there's a compelling need for the testimony. And the judge just testified regarding records. He didn't testify for or against one of the parties.
Well, the compelling need, I think, it would be if there was no other evidence available to prove sobriety person. Example, if the only person who saw the defendant that particular day had been the judge, bumped into him walking to the courthouse, saw him at Kmart that morning, or judge's shop too, you know, and
Right.
That kind of thing, where the judge is the only one who saw him. But here, the state had plenty of alternatives. I mean, I conducted those hearings before as a trial judge,
Right.
and when you do first appearances in the courthouse, I mean, there are a number of people around. There are deputies, there are police officers present who can come in and testify he was sober. There's court reporters. There's lots of people. You can even call someone in the state attorney's office who was present to testify. And using a judge to come in and testify and tell a jury, I'm a judge and I'm telling you he was sober. When there's a videotape and there are other witnesses that can testify to that, I mean, I can't think of anything more prejudicial. And it's a factual matter whether he was sober or not. The jury can look at the tape and see if he was sober.
Correct, Justice Labarga. The jury can see whether or not he's sober.
But counsel, you did point out that there are questions about the quality of the tape, and the evaluation from this grainy tape is different than the evaluation of someone who was there, who had the responsibility to decide that he was competent to enter the guilty plea. Isn't that true? That's fundamentally different.
His trial attorney was standing right next to him the whole time, Mr. Colley, and he had the duty to make sure that Mr. Colley was competent and not impaired to issue a guilty plea.
Well,
and
but here's the reality. You don't contest that it could be admitted that a determination had been made that morning that he was competent to enter the plea, do you?
I think there needs to be an evidentiary hearing to make that determination. That's one of the things I'm asking for this court, to remand for an evidentiary hearing on this issue. We need an evidentiary hearing.
No, I'm talking about the historical fact of what happened at that hearing. You don't contest that was admissible.
I don't contest that it was admissible. It was not admissible through the testimony of a sitting
Okay, you
courthouse
contest that
judge.
it was admissible. What you're contesting is the way it came in. But it seems like to me, once it comes in, then this whole thing kind of dissolves into kind of quibbling over not much. Because if the historical fact that the judge at that hearing, that injunction hearing, had made that determination can come in, then whether you get the testimony directly from the I just don't see the prejudice in getting the testimony directly from the judge if it can come in that the determination was made.
Well, before I can even concede admissibility, we have to look at the context of this case. And in the context,
I thought you'd already conceded it. To me.
Well, I just conceded it on the record, but we didn't raise a admissibility claim, so I want to stick to the context of the claims that we raised. So assuming it was admissible, and we're assuming that this information regarding impairment is admissible, then it needs to come in through another witness who's not prejudicial, who's not being called judge with 28 years of experience, who's not being cross-examined by his own trial counsel referring to, hey, Judge Tinlin that, Judge Tinlin this, in front of a jury. That's extremely prejudicial when they could have called the same trial attorney, Kyle Bedrins, who testified in guilt phase. The guilt phase attorney could have testified to the exact same testimony.
Well, I mean, the problem is here, and I understand you're doing you've got to do the best you can with what you got, but the problem is these facts are highly prejudicial. I mean, he had this hearing where he seemed to be performing very well, but that's just what happened.
Yeah.
And it's inconsistent, it seems to be, or at least one could take the reasonable view that it's inconsistent with the story about that he's under some kind of state where he doesn't really know what he's doing, when he's there demonstrating that he does know what he's doing. And so that's what's prejudicial here. Whether the judge is talking about it or not seems to me to be a matter of minor significance in the context of what the actual facts are. Now, I understand you don't agree with that, so tell me why I'm wrong about that.
Well, the defense made impairment an issue at trial. So in rebuttal, the state called a sitting courthouse judge, Judge Tinlin, to testify in rebuttal. They could have called, if impairment's an issue, then call the trial attorney, Kyle Bedrins, call the prosecutor, Josh Bird, who was there for that process. As Justice LaBarga mentioned, other witnesses are there other than somebody using the influence and power of the judicial bench. And speaking of what Mr. Colley was going through, he wasn't just impaired with intoxicants. He's a poor metabolizer for a drug called Cymbalta. And that's claim 7 of our motion. The fact that Mr. Colley is a poor metabolizer for this drug, if the jury would have heard this information, it would have humanized Mr. Colley. Mr. Colley was doing everything he could to try to save his marriage. He was spiraling. He was crashing out. He was having so many mental health issues, substance abuse issues. He went to go see a doctor saying, "Hey, doctor, I need something for what I'm going through." The doctor prescribed Wellbutrin. Turns out Mr. Colley's also a poor metabolizer for Wellbutrin. But the switch from Wellbutrin to Cymbalta 17 days before the crime also exacerbated these issues. And that's also the reason Mr. Colley's sitting on death row today.
On this issue, I think that's all. Those are all facts that are part of the context of the case as it comes to us. But on this issue, this presents as a Strickland question, right? And so the question is the prejudice that results to your client as a result of the judge's testimony and the lawyer's failure to object to it. And I guess what I'd like to hear is your argument that your client would have received a life sentence but for the judge's testimony, because I think that's a really tough road to hoe.
Our client would have received a life sentence but for the judge's testimony, because jurors are taught to believe and trust judges. Judges and justices wear robes. We stand up when they come in. The state mentioned in their answer, and I think the trial court might have mentioned, this is no different than a police officer testifying in a trial case. It's extremely different. Jurors watch TV shows, they live through life. They might have equivocal opinions regarding police officers, not when it comes to judges. And here in Florida, we have canons. The state cited to the canons in their answer brief. Canon 2A. The impartiality of the judiciary, the integrity and the impartiality of the judiciary.
Well, but is your argument that that Judge Tinlin violated the judicial canons by testifying when subpoenaed by the state or called by the state?
I'm not saying he violated the judicial canons. I'm saying this state treats judicial testimony extremely differently.
I understand, but I'm having a hard time understanding the relevance of the canons to the decision we have to make. Because
we also talk about the prestige of the judicial office, citing Canon 2B. So if we're treating judges differently when it comes to them testifying, like for somebody in a bar grievance, because they have this higher standard, then we need to keep that same analysis and that same energy for a capital case with somebody's life at stake. So judges are not just common witnesses. Case after case, in different contexts, this state treats judges as.
But this parade of horribles I'm not impressed with, because this is a pretty unique situation where the mental state of a defendant is related to crimes that happened later in the day. Was also an issue in a judicial proceeding that was conducted earlier in the day. That doesn't happen that often. I'm not saying it would never happen, but it's certainly, I don't see that if we decide this adversely to you, that means there's going to be a parade of judges testifying. This is a circumstance where the judge actually had to make a determination about the competency of the defendant. And that's what we have here, and that's different than other cases where somebody might just want to call a judge. The parade of horribles didn't impress
So
me.
if the judge makes a determination regarding the competency or the impairment of the defendant in front of him or her, that also goes to that judge's mental impressions. So I also like to also cite some supplemental authority that I plan on adding after this hearing. U.S. v. Morgan.
Well, you need to let people know about your supplemental authority before you come in here talking about it.
Okay, I'll cite it and the court can do with it what it will, but it just talks about exactly what we've been saying, the necessity regarding a judge testifying. U.S. v. Morgan, 313 U.S. 409. That's a 1941 case.
I don't think you heard me.
I heard you. Also, I will be doing a supplemental authority for U.S. v. Roth, which is cited as 333 for F second, F sub second, 565. Heightened scrutiny. So that's when the defendant wants the judge to testify. So we're still talking about heightened scrutiny, need, necessity, case after case, whether you want the state wants a judge to testify, the defendant wants a judge to testify, or a civil case. We need necessity, heightened levels of scrutiny, which we don't have in this case. But perhaps we might be able to get it if we were remanded for an evidentiary hearing. If we're going to do something in this state that allows a judge to testify in a capital case, something of such grave importance, I'd ask this court to remand for an evidentiary hearing so that we can see what trial counsel had time to do, or what trial counsel's strategy was, what their tactical decisions was. Something this grave, this important.
But none of that would be relevant to the prejudice issue, which it seems like a lot of the questions have been focused on that.
Well, prejudice is going to come out as part of the evidentiary hearing. Once there's an evidentiary hearing, we have to find out what the facts are.
No, I mean, we're talking about the facts that might go to the reasonableness of the sort of the first prong of the Strickland test. But let's assume that the counsel should have objected to this. I mean, you'd still like what more would we know about prejudice if there were an additional proceeding on that?
If there's an additional proceeding, then we would know what trial counsel strategy was. And regarding prejudice, more would come out regarding prejudice as far as what Mr. Colley was going through, particularly the fact that he was improperly medicated with Cymbalta at the dosage that he could not metabolize. 3 experts testified to that.
So that's a separate issue, though, from the judge issue.
Right. Exactly.
And as to just to sort of close the loop on the judge thing, I mean, the prejudice would be have to, it would be evaluated in light of everything else, the aggravating factors, all of the other ways. I mean, I'm not really sure, given the fact that obviously there was a full airing of all, of your client's kind of perspective on his mental state and everything, both the jury and the sentencer were able to consider all that, and they still made the decisions they did. So it seems hard to believe that this would tip the scales potentially sufficient to meet that prong.
It would tip the scales because we have a jury was there, and the jury heard a sitting judge say that he seemed okay to me. I stand here with the state. I'm paraphrasing, but by a judge testifying as a judge with 28 years of experience for the state in a capital case, just like a police officer.
Well, are you arguing that it's? It seems like you're almost arguing that it's structural error, but you really haven't argued that. You aren't arguing that it's. You have not argued that it's structural error, have you?
No, prejudice.
Okay. So you concede that we got to show prejudice, but then you are in effect arguing that if it's not structural error, it's close to structural error because just having a judge testify is such a devastating thing.
Well, this court needs a record to see exactly how devastating it is, so that's why you should remand for an evidentiary hearing to see what other witnesses could have testified.
What's devastating in this record, I think many people would say, is not has nothing to do with what the judge did. There are a lot of devastating things in